We are coming to you live from Los Angeles. Unfortunately, hindi po kayo pwedeng tumawag sa amin mula sa Hawaii. But don't worry, I'm sure this is very informative for all of you. And we have a caller on our line, si Peter from Panorama City. Peter?
Hello, good afternoon.
Good afternoon po. Ano pong tanong ninyo?
Kasi green card holder ako. Ngayon, married na ako ng may marriage ako ng 2 years. Yung babaeng napangasawa ko is a tourist but she's out of status. Ma-change ba yung status niya dito sa America?
Okay, so he does have a green card. He's been married for 2 years. His wife is a tourist but out of status.
Yeah, this is a kind of particularly quirky situation. Although he can file a petition for her and get that petition approved, her adjusting here is going to be a little bit more problematic because as a spouse of a permanent resident, she needs to be in status if she's going to adjust. So if she's overstayed, she's going to have to wait until her husband, until you become a U.S. citizen. And then the overstay won't matter. As long as she has a legal entry, married to a U.S. citizen, she can adjust without an issue.
Okay, so, and from the time he got his green card 2 years ago, how many years before he can apply for citizenship?
It's 5 years.
5 years on top of the 2 years?
No, it's 5 years from the time he became a permanent resident or conditional permanent resident. So, but I'm assuming he's a permanent resident. So.
Okay. All right, we have Delia on the line. Delia, nandyan ka ba?
Yes, good afternoon sa inyo.
Good afternoon po. Ano pong tanong ninyo?
Galing sa anak ko, kasi nag-asawa ko na US citizen, tapos pinitisyon niya kaming dalawa.
Okay.
Ngayon, namatay yung asawa kong 2008, ako nakuha ko yung green card ko ng 2009. Ngayon, gusto ko lang malaman kung ililipat ko sa akin yung pagpipetisyon ko, mapapabilis ba o lalong matatagalan?
Okay, so she is married, Delia is married to a U.S. citizen who petitioned her and her child. However, he passed away. So what she's asking, will it be faster if she goes ahead with a petition or she does the petition?
Well, in that particular regard, 2009, you're probably eligible for citizenship already. So she may want to go ahead and proceed with the citizenship application, and that might be the option that she can take for her child. Alternatively, if there was a petition filed for her child prior to her husband's passing away, there might still be an opportunity as based on a widow, based on a child of an individual who has passed away. So that option should also be explored. So fortunately, in her situation, she does have a few potential opportunities to bring her child into the U.S. The age of the child is also a factor that we need to take a look at. And so definitely in her situation, the facts are so many that she really should go in, speak with an attorney.
All right. Okay, Norma, nandiyan ka ba?
Nandito po ako.
Ano po yung tanong ninyo para sa ating immigration lawyers?
Yes, ang tanong ko po ay, ngayon ako'y green card holder. Pinetition ko po ang anak ko na nasa Pilipinas as F2B noong 2009.
Okay.
Ang concern ko po ngayon ay kung pwede na po ba ako mag-file ng citizenship.
Okay. So she's asking, you know, she has a child that she petitioned in the Philippines since 2009. Can she file for citizenship?
And I think you can see from the questions,
right,
there has been ongoing confusion because, as we've pointed out, historically, Filipinos knew don't become a U.S. citizen, otherwise you're going to lengthen the waiting list for your children. And that's why when this change took place last August of 2004, it was a very big change, and a lot of people still don't realize that that change has taken place. And so as Richard had spoken about earlier, it is better to become a U.S. citizen at this point in time because the waiting list for that category is shorter. And if by chance that category starts backing up, you can still go back to the F2B category for petitioners who are green card holders. So there's all sorts of advantages to becoming a U.S. citizen, the ability to vote, the ability to serve on a jury.
Take advantage of it.
They need to do it for the sake of their children.
That's right. Okay, so Ben is on the line right now. We're taking one last call before we go to break. Ben?
Yeah, I have a friend who was a crewman, and then he had U.S. citizen children. Like they say that
gaano ba katagal kung kailan makukuha yung green card? Dahil US citizen yung anak.
Okay, so he's asking about how long it's going to take for them, the parent, to get their documents if their child is a U.S. citizen.
Well, this is a very interesting problem because part of the issue is that person came in as a crewman. So normally what you would say is that the child must be 21, a U.S. citizen, before they can petition their parents, and at that point, if the parent came in lawfully into the United States with a legal entry, then they can adjust. But as a crewman, you can't do that. So unless that person is 245I qualified, that is, has a petition that was filed prior to April 30th, 2001, you cannot adjust your status here in the United States. They would end up having to do what would be called a provisional waiver, that is, filing a waiver application for the time that they were here unlawfully and then consular process back in the Philippines. But again, waiting until the child is 21 years old.
All right.
Or alternatively, in that particular situation, if they are ineligible to adjust or do the provisional waiver, perhaps they came in before January 1, 2010, and maybe they can go ahead and proceed with a deferred action for parents when that becomes available later this May.
All right, so we're going to break, but please do give us a call here on Kababyan today. We're taking your questions about immigration, 1-800-553-5724. We'll be right back with our last segment here on Kababyan today.